Hi, everybody. My name is Brian Cancian. Welcome to Foundation's educational webinar series. It's just about 2:01. We still have some people trickling in that have registered, so we're going to give it just a couple minutes before we actually get started. So sit tight, and we'll be right back with you.
Six-bedroom boundaries that turn women on. Want to know something women focus on?
All right, everyone. Looks like we have a pretty good audience joining us already. Welcome back. Again, my name is Brian Cancian. I'm the Business Development Manager here with Foundation Software, and welcome to our educational webinar series. Today we have Andres Gallego, with Han Loewryn. He's going to be presenting the 2025 OSHA mid-year update. Andres?
Thank you, Brian. Hello, everyone, and thank you for joining me today. As Brian said, my name is Andres Gyorgy. I'm an associate attorney at Han Loewryn Parks, and I'm a member of Han Loewryn's OSHA practice group. Today, we'll discuss some mid-year 2025 OSHA updates and present a refresher on what to do when OSHA comes knocking. First, we'll talk about changes in leadership with the incoming administration. As you may know, the incoming president is able to appoint their cabinet secretaries with the advice and consent of the Senate. President Trump's acting Secretary of Labor, Lori Chavez de Remer, was sworn in on March 11th, 2025. In her position, she is the top labor policymaker overseeing the Department of Enforcement's rulemaking and worker protection initiatives. Previously, she was a U.S. representative for the 5th District of Oregon, and she has a background in business with a strong emphasis in employer perspectives and labor policy. She is uniquely a pro-labor Republican, and this introduces some uncertainty for employers. Many expected President Trump to appoint a pro-business or even overtly anti-union Secretary of Labor. And while a second Trump administration is still expected to reinstate employer-friendly policies, changes to the independent contractor rules and joint employer liability and/or rescind workplace safety regulations, Secretary Chavez de Remer's history suggests she may take a more balanced approach. President Trump's nominee as the acting Secretary of Labor for OSHA is David Keeling. He began his career at UPS in 1995 and eventually became the Vice President of Global Health and Safety. He most recently served as the Director of Global Road and Transportation Safety at Amazon. On June 5th, Mr. Keeling appeared before the Senate Committee on Health, Education, Labor, and Pensions, also known as the HELP Committee. Mr. Keeling's nomination has generally been well received by stakeholders across the spectrum from labor to employee rights advocates and employers alike. Key members of the business community appreciate his solid technical safety credentials and hands-on experience with workplace safety and having been encouraged by his interest in public and private partnership. Currently, his nomination is out of committee and a full vote is expected in the near future. The Deputy Assistant for Secretary for OSHA is Amanda Wood Lehau. She's a former commissioner of the Occupational Safety and Health Review Commission, also known as OSHRC. That is the independent agency that hears cases and appeals involving contesting OSHA citations. She was also a former director of labor and employment policy for the National Association of Manufacturers, where she advocated on key issues related to employers' health and safety. Notably, the political deputy assistant role at OSHA does not require a Senate confirmation. Thus, Ms. Lehau moved immediately into the position as acting secretary until Mr. Keeling's nomination is confirmed by the Senate. Ms. Lehau's deep expertise in labor policy and occupational safety law positions her as a key figure in shaping OSHA's regulatory approach and ensuring the effective implementation of occupational health regulations. Like Mr. Keeling, Ms. Lehau's written decisions while serving at OSHRC demonstrate her to be a serious, reasonable, and qualified candidate for the leadership role at OSHA. And all that information about the leadership at OSHA is important because while President Trump's choice of leadership at labor appears to be more balanced, time will tell how they'll shape enforcement and policy. During the first Trump administration, generally there was an attitude favoring deregulation, which slowed and reduced rulemaking. If history repeats itself, which writing on the wall says it may, we will see a more employer-friendly approach to policymaking. This may occur through scaling back or even stopping the use of press releases and safety health data to publicly shame employers, roll back enforcement policies and practices adopted by the Biden administration, such as OSHA's expanded application of instance-by-instance citation policy, lowered thresholds for inclusions to severe violator enforcement programs, and a more aggressive use of egregious, willful, and repeat citations. In other words, OSHA may not be using all the tools in its toolbox in the future. Some may be dulled, and some may be put away for the time being. Promises made, promises kept. The Trump administration campaigned on dismantling the administrative state of the federal government. By the end of the first Trump administration, OSHA had shrunk to the fewest number of compliance officers in the agency's history, dropping from 925 co-shows to 761 by the end of the first Trump administration. And the agency had a record number of vacancies in the middle management positions throughout the area and regional field offices. The Biden administration rebuilt some of the ranks at OSHA and filled many of the agency vacancies. And by the end of Biden's administration, the number of co-shows was back up to 878. However, writing's on the wall that during the second Trump administration, OSHA will experience another major contraction through DOGE cuts. Critics of these cuts argue a smaller OSHA means less resources to conduct inspections, engage in robust enforcement, and work on or promulgate new standards. Meanwhile, the Secretary of Labor has recently stated that a smaller budget will require OSHA to modernize and streamline the agency. There have also been challenges to OSHA's authority. Recently, as of January 3rd, 2025, Rep. Andy Biggs introduced the Nullify Occupational Safety and Health Administration Act, also known as NOSHA, causing immense speculation about OSHA's future. Proponents of the act say OSHA is an unconstitutional federal agency and regulation should be left to the states. It also is that over-regulation hurts small businesses and makes it difficult for business to expand and grow. Opponents of the proposed act say this would be a catastrophic step backwards for worker safety, would leave many workers vulnerable to unsafe working conditions, and the most vulnerable low-income and minority workers will bear the brunt of the dangerous rollbacks. As of right now, the act is unlikely to be successful. If you recall School of House Rock, a bill has to be passed out of committee, then voted on by the House, then the Senate, and then signed by the President before it's put into law. As of right now, there's no vote to move this bill out of committee. There have also been legal challenges recently to OSHA's authority. Recent Supreme Court decisions like Loper-Bright, Corner Post, and Gyorgy bolster efforts to rein in federal agency action. Loper-Bright was a significant case because it overturned what is commonly known as the Chevron deference. This is a legal doctrine that required courts to defer to reasonable interpretations of ambiguous statutes made by federal agencies, meaning that if a statute is unclear, courts would be required to accept the agency's interpretation as long as it was permissible. The idea was that the agencies themselves have the expertise and in their respective areas and should be allowed to interpret the laws that they administer. This is no longer the case, and courts can now use normal rules of statutory interpretation to determine the ambiguity themselves. Connor Post was a significant decision because it makes it easier for an entity to challenge the government agency. Under Connor Post, a claim or an injury does not accrue until the plaintiff is actually injured by the final agency decision. Because litigants can bring a civil action against the government challenging the regulations only after they are injured, the clock does not start until the regulation. The clock does not start when the regulation goes into effect, but when the entity becomes injured. Gyorgy is a significant decision as well. It involved the SEC, where the SEC was seeking civil penalties against a defendant for securities fraud, and the Seventh Amendment, and the decision was that the Seventh Amendment entitles the defendant to a jury trial. So the significance here is it broadly calls into question whether any federal regulatory agency can bring in-house proceedings to enforce civil penalties. This is particularly noteworthy because some agencies, such as the SEC, may choose whether to pursue civil penalties in federal court or via an in-house administration proceeding, while other agencies, like OSHA under OSHA, are only statutorily authorized to pursue enforcement through in-house proceedings. Another recent legal development was all states were factory contractors. The issue there was whether Congress delegation of authority to OSHA to write reasonable and necessary or appropriate workplace safety standards violated Article 1 of the U.S. Constitution. Despite the Supreme Court's denial to review it, it shows where opponents of OSHA are aiming their sights. These legal challenges impact OSHA in the following ways. It questions the validity of the OSHA Act. It creates potential for additional defenses to citations. It slows rulemaking through interpretation, impacts the ability to implement national emphasis programs or NEPs, and opens the door to other challenges. Despite the uncertainty around OSHA's future, penalties did increase in 2025. As you can see from the chart on the screen, penalties slightly increased from 10 to 15%, with willful and repeat violations reaching up to $165,514 per offense. Next, we'll talk about some updates to new final rules. With respect to personal protective equipment or PPE, effective January 13th, 2025, employers must ensure PPE worn by employees in the construction industry properly fits and is of safe design for the work that is being performed by the employee. With respect to the employee representative walk-around rule, or commonly known as the walk-around rule, it amends an existing rule and now allows employees to have a third-party representative to join them during the walk-around inspection. Proponents of the rule say that this is pro-labor and provides for greater transparency, while opponents of the rule say this is anti-employer and can allow for a multitude of third parties to gain access to the work site over objections of employers, makes it easier for unions to get access to non-union workspaces, allows plaintiffs' attorneys and or their experts to exploit the rule and conduct pre-litigation discovery in personal injury or wrongful death actions in a way that's not currently allowed by the federal rules of civil procedure, and may also create a security risk for competitors to gain access to proprietary information. Currently, a coalition of business groups in the Western District of Texas have brought litigation to challenge the rule. Given the Trump administration's stance on deregulation, they may choose not to defend the challenge to the walk-around rule amendment. With respect to hazardous communication, the OSHA Hazard Communication Standard, or HCS, is designed to ensure chemical safety in the workplace. It requires that all employers with hazardous chemicals must develop and disseminate information about the hazards associated with those chemicals, including labels and safety data sheets, and train workers on how to handle them safely. The standard aims to classify the hazards of those chemicals produced or imported and ensure that the information is communicated effectively to both employers and employees. The updated standard will require labels on small packaging to be more comprehensive, readable, and make changes to help ensure trade secrets are no longer preventative to workers and first responders from receiving the critical hazard information on safety data sheets. Changes include clear hazard classification, clear hazard classification process to provide more complete and accurate hazard information on labels and safety data sheets, update physical hazard classes to better inform users of safe handling of explosives, aerosols, and chemicals under pressure, and updated precautionary statements on how to safely handle and dispose of hazardous chemicals. With respect to workplace injury tracking and reporting, there was a recent update, and establishments with 100 or more employees in designated high hazard industries must electronically submit to OSHA detailed information about each recordable injury and illness entered on their previous calendar year from OSHA's Form 300 long and Form 301 incident report. This includes the date, physical location, and severity of the injury or illness, details about the worker who was injured, and details about how the injury or illness occurred. All entities are required to submit information from their OSHA Form 300 long and OSHA Form 301 incident reports to OSHA, and under this rule are already required to collect and retain this information, and are currently required to electronically submit to OSHA the information from their OSHA Form 300A annual summary. The rule did not affect the existing requirement for establishments with 20 to 249 employees in certain industries to electronically submit information from their OSHA Form 300A annual summary to OSHA once a year. The rule retains the requirement for establishments with 250 plus employees in industries that must routinely keep records to electronically submit information from their OSHA Form 300A annual summary, and each entity must provide their legal company name when submitting their data. This is a great example of the shift in policy between the administrations. This was originally an Obama administration rule, and then in the first Trump administration, reporting requirements were diminished. Then when Biden became president, he reinvigorated the reporting requirements, and again, we're likely to see a shift under the second Trump administration to diminishing the reporting requirement. Now I'll give an update on rulemaking. The heat and illness rule has been a hot topic for a while, and unfortunately, we're probably not going to get a final rule anytime soon. One way or the other, if you're for it or against it. So the proposed rule would apply to all employers conducting outdoor and indoor work in all general industry, construction, maritime, and agriculture sectors where OSHA has jurisdiction. The rule would require employers to develop and implement a comprehensive site-specific written heat, injury, and illness prevention plan, also known as an HIIPP, which must include a list of all work activities covered by the HIIPP, all policies and procedures necessary to comply with OSHA's heat illness rule, the employer's chosen heat metric, and identify one or more specific heat safety coordinators. This rule is controversial because it broadly applies to multiple sectors, and one size does not often fit all. Some trends that we have seen from legal challenges or just legal developments. Florida and Texas have enacted bans to local governments requiring heat protections for outdoor workers that are not already required under state or federal laws. In contrast, Illinois has proposed an act that requires employers to develop a comprehensive plan to prevent temperature-related occupational illness and injuries. The act applies broadly, but it does not apply to any employees directly involved in the protection of life or property, such as lifeguards, firefighters, paramedics, law enforcement, and employees engaged in the emergency restoration of essential infrastructure and services, which includes roads, bridges, utilities, and communications. Similar to the proposed OSHA rule, the Illinois Act creates a standard that sets a temperature hazard level for employees that, if triggered, requires mandatory employer action. It requires the employer to develop, implement, and maintain an effective occupational temperature-related illness and injury prevention plan. With respect to the OSHA heat illness rule, there was a hearing on June 16th of this year. However, it is unlikely we'll see a final rule anytime soon. OSHA has continued to review updating the lockout tagout standards to address the increasing prevalence of computer-based controls. However, it is unlikely again that we will see new rules or regulations in the near future due to the current administration's desire to deregulate and slow rule promulgation. With respect to welding in confined spaces, OSHA is proposing to amend the welding and cutting standard in construction to eliminate any perceived ambiguity about the definitions of confined space that applies to welding activities in construction. New guidelines are being addressed to ensure employees have the tools and knowledge needed to stay safe in confined spaces. A projected publication date for the new standard was to occur in May of this year. However, as of today, it has not been updated. We'll now discuss some continuing areas of focus, and these are all national emphasis programs, or NPEs, which are temporary programs which OSHA is focusing the resources on particular hazards and high hazard industries. Preventing fall hazards was announced as an NEP in 2023 and remains in effect. Fall hazards continue to be the leading cause of fatal workplace injuries and violations that the agency cites most frequently in the construction industry inspections. Trenching and excavating NEPs from 2018 remain in effect. The NEP was originally issued to address the increase in trench and excavation collapse and loss of life. As part of the program, COSHOs, the OSHA inspectors, shall initiate inspections whenever they observe an open trench or excavation, regardless of whether there was a violation readily observed. The standard that OSHA is trying to set is to provide protective systems on trenches deeper than 5 feet. Soil, materials, and equipment must be kept from the trench's edge. The trench must be inspected by a knowledgeable person. The employer must provide an accessible means to safely ingress and egress and confirm the trench is free from standing water, hazards, and indications of collapse prior to allowing a worker to enter. As previously mentioned, the heat illness final rule is not coming anytime soon. However, OSHA has extended the heat NEP for another year, meaning OSHA will continue to use the general duty clause as a stopgap method of citing perceived heat hazards. It is important to continue to implement and reinforce best practices, including developing an HIIPP, training employees, and providing rest, shade, and hydration. With respect to mental health and substance abuse continues to be an area of emphasis for OSHA. This is motivated by the fact that construction employees tend to have suicide rates 5 times greater than other work-related fatalities. Also, the construction industry has the highest death rate attributed to overdose by occupation. Rather than regulating by rulemaking, OSHA is committed to bolstering education, outreach, and promoting best practices and prevention efforts. And this will likely continue during the second Trump administration. And next we'll have a refresher on what to do when OSHA comes knocking. To recap the OSHA inspection life cycle, first there is an opening conference, followed by a document production, then a walk-around inspection, employees are interviewed, there is a closing conference, citations are issued, and then finally citations are contested. During the initial reception and opening conference, it is important that you politely greet the COSHO and be mindful that conversations you may have could be used against you. It is important that you seat the COSHO away from employees and preferably in a private conference room away from work activities. Contact a corporate representative. The corporate representative should be the only person communicating with the COSHO at that point. Once the corporate representative is involved, that individual should ask to see the COSHO's credentials, ask the COSHO to state the purpose of the visit, ask the COSHO whether they have a warrant, and this is important because without a warrant, the COSHO cannot conduct an inspection without consent. If the COSHO does not have a warrant, negotiate the scope of the inspection, documents to be produced, witnesses to be interviewed, and parts of the facility produced for inspection. With respect to the walk-around, the corporate representative should accompany the COSHO at all times. The COSHA must be required to wear all applicable safety equipment or PPE. Take the COSHA to the inspection area using a route aimed at limiting the potential scope or items that can be readily observed. If the COSHA takes any photos, videos, the corporate rep should also take replicas of those photos or videos. The corporate rep should also identify any document hazards identified by the COSHA and the method of correction. And if any test is required, request that the sampling or testing be rescheduled for a time where the employer can also perform identical sampling and testing. COSHAs have the right to interview non-managerial employees privately. To the extent that you can, only produce employees during regular work hours if it does not pose a hazard or risk to others or operations. Inform your employee that OSHA may ask them to guess, OSHA may take a written statement, and OSHA may ask them to sign a statement. The employee does not have to sign, but if they do, they can and should request a copy. Employees can have a union shop steward or their own counsel present during the interview. With respect to managerial employees, these are generally defined as those employees who have the right to bind the employer. In practice, an employee who can hire and fire, supervises one or more persons, or is considered a foreman may be considered a manager for the purpose of the managerial employee interview. Managerial employees may only be interviewed with a corporate representative present. Unlike non-managerial employees, seek to schedule the managerial interviews after work hours. Meet with each managerial employee prior to their interview and instruct them not to comment on issues outside of their firsthand knowledge, not to speculate. Do take notes during the interview and exercise their right not to sign a written statement. During the closing conference, it is important that you attend, listen, and avoid making any comments. Do take detailed notes. Ask if there are any matters that need to be corrected by the employer. Ask about citation classifications and penalties, and abate any immediate issues if possible. Request an itemized receipt of all items and documents provided during the investigation, and if additional items are requested by the COSHAs, request time to produce that information. Finally, seek guidance from general counsel, from your counsel, relating to potential citations or follow-up items. And to summarize, the change over the Department of Labor and OSHA's leadership appears to be more balanced between pro-labor and pro-employer. However, writing's on the wall that OSHA will experience another contraction in its budget and reduction in its workforce. Rulemaking and policy will most likely slow down, if not halt completely during for the time being. With that said, even if the numbers are reduced, COSHAs are still out there, they're still conducting investigations, and they're still issuing citations. The existing rules and NEPs are still in place, and be knowledgeable of what to do when OSHA comes knocking. And I appreciate you all joining me today, and Brian, I think we can open up for questions.
Yeah, absolutely. So we do have a poll that's going to get launched here in just a moment. If you guys would all be so kind as to give a quick response to that. And once that is wrapped up, we are going to open it up to Q&A. You should see a little question icon up on the toolbar. On my screen, it's over on the top right area. That'll open up the question thread. Please feel free to type in any questions that you might have for Andres, and we will go through and answer those as best we can. We have some time remaining, so definitely ask away. .54% participation in the poll. Come on, everyone. And like I said, there are questions available up at the top right of your GoToMeeting control panel or GoToWebinar control panel. Just open up that pane, type your message into the dialog window, submit that, and we will go through those as they come in. Q&A is open. I guess I just have a general question for you, Andres. What do you find, most of your clients that are coming to you with OSHA related issues, like what is really one of the top concerns?
One of the main concerns is when they do get a citation, it is attempting to lower the severity of it. So the initial fines are not an exorbitant amount of money. Other than serious violations around $16,500. The problem is that if you get repeat violations, that's when you get the big jump up in the fine. So mostly what we'll see is, you would get the citation for an event, and it's easy to think, well, I can just pay off that fine and be done with it, like pay the parking ticket, move on, I don't have to go to court.
Right.
The problem is that it goes on your record, and that's where what we will more often do is try to contest the serious violation to get it reduced down to other than serious, and that way the history and the track record is not being built on that entity's record with OSHA.
Got it. No, that's good. Good to know. Are there any solutions out there that you're aware of that employers can use to just help track their activities in OSHA compliance and information, things that, I imagine if I get a citation, right, and I want to dispute that, I am going to need to show proof of action that I've taken to prevent situations, to do things. What do you see available out there? Do your clients use software? I know we have Safety HQ. What do you see your clients doing?
Specific software or checklists I know are available, but as I sit here presently, I can't name any one individually. But the key thing is to document everything as much as you can, and keep a record of all of your efforts to abate issues and to follow the safety guidelines, and keep record logs if it's things for lockout, tag out, anything that an inspector would want to see. If you keep the clear copies of that, it's going to make it easier to defend your case. One of the problems is when there is a lack of documentation, they're going to assume the worst case scenario. And even in some instances, not having the documentation is an offense itself.
That's great. I'll do a shameless plug here for the Foundation family of products. For those of you that are still here, we do have Safety HQ. You've probably heard the name once or twice through our marketing materials. Tool designed exactly for that, to track all of the safety and education training certifications, et cetera, out in the field on your job site, to really just do that, to provide the documentation to support you as the organization, as the employer, should an occurrence ever happen. So feel free to reach out to Foundation, schedule a quick demo if you have not yet seen one. All right, I don't see any questions. 55 people left and nobody typing questions. So we're going to
Brian, we do believe we have some questions in. For folks who are interested in copies of the recordings or the slides, everyone will get a copy shortly. We also have some content-specific questions for Andres. So first one being, what was the heat safety training called again?
So it's a final heat rule, it's not final. So if what the rule would require would be for the employer to develop a heat injury and illness prevention plan known as a HIPP, HIIPP. And generally, the employer would be required to list all the activities that would be covered under the HIPP, all policies and procedures necessary to comply with OSHA's heat illness rule, what metric is being used to track the heat when it reaches a certain threshold. I believe the one in Illinois, which is where I'm located, is 90 degrees. That's when the employer response would be triggered, and then identify one or more specific heat coordinators. There are resources online that we can share out that give like the list and breakdown, and then also all this information's on the Department of Labor. There just isn't a final rule that has been entered yet. And again, it's what we're seeing, and most likely we'll see during the second Trump administration, will be a shift towards state-by-state regulation. So again, Florida and Texas are saying that local governments, so the city of Miami can't come up with a rule that is greater than the state of Florida. The state of Florida have to pass something. And that's where you see Illinois is passing a rule statewide. So if the federal government fails to act, you may see states try to act. And the biggest problem with the federal OSHA heat rule is that it really is broad, and one size does not fit all. So if you're in a southern state, you're going to have days that have excessive heat according to OSHA's metrics more often than a state that's in the north. And that's where some of the controversy is with the rule today.
Great. I do now see the questions, technical difficulties here. So we definitely have a few. So Teresa has asked, after you have received a document request and submit the response, how long is it generally until the case is closed?
Depends on what, and I don't want to take the legal answer, but it depends. So case being closed means, or it could mean a couple different things, right? So are you referring to when the citation is closed, when it's and the end of the contesting of the final citation and the decision assessing a penalty? It generally can take some time. So the citation, I believe, is relatively immediate. The COSHA will come out, they would do their investigation, they would issue the support, maybe a couple days or a week later, issue and send out request for information or just the final findings that they have. And then there's specific time frames of when you can contest that after you receive it. And then if you do contest it, it can take some time. It is a administrative legal proceeding, but still there's a backlog of these, and the resources for OSHA to administer these hearings is being reduced.
Okay.
Teresa, I hope that answered your question.
Sarah asks, how long does it stay on your record? I know DART and mod rates, etc., have a time frame.
That is a good question, and presently I do not have that information available, but it's something I'm happy to follow up with Sarah about.
Let's go to Michael. Can OSHA come for a specific investigation and end up investigating something else? Are there specific guidelines that they need to follow when investigating or once they're on a site, or is it a free-for-all?
The answer is yes. OSHA can come for a specific purpose. If an employee were to contact OSHA for some reason, something that they observed, and OSHA comes out for that specific purpose, anything else that COSHA sees is fair game. And the other part of the question, yes, there are some guidelines that the COSHA needs to follow, but again, if it's something that is observable to them, it can go in the report, it can become a new citation, and becomes a new problem. And that's why when we were talking about what to do when OSHA comes knocking, you want to keep the COSHA as far away from work activity as possible if it's unrelated to what they're there to inspect. And that's why you ask them the question, what are they there to see? what brought them there today, and try to keep them as far away as possible from anyone that is not necessary for them to talk to.
Great. Marlo is asking, as an employer, I know we are able or are supposed to supply water, but are we expected to provide electrolyte flavored packs?
Not that I know of. I would have to go look at the heat rule to answer that specifically, Marlo. But yes, you would be required to provide water and then just take the shade, the rest, the hydrate approach. But electrolytes, that is a good question. I have not seen anything specific about that.
Jenny's asking, I've looked at the heat standards and they reference PPE, but not what that PPE could be. Any idea what is required?
The PPE is going to vary from situation by situation. So I know when we're talking about the heat rule encompasses both heat and cold, or at least the Illinois state version does, because it gets cold in Illinois. But specific to heat, I do not know what specific PPE that would be. And I don't want to speculate, but that is something that I would be happy to look into and follow up with.
Great.
I just know the PPE needs to be appropriate for the work that is being done and for the industry that you're in.
Great. Jake asks, what causes a warrant to be issued for an inspection and who is authorizing the warrant?
That's a good question. The warrant could be caused by a complaint that was filed by an employee, someone who observed some form of a OSHA violation, and the warrant is being issued by OSHA themselves.
Excellent. Excellent. How about if the Trump administration changes anything, what is the best source to stay updated on those changes?
Not to promote myself and my firm, but legal blogs like Han Loewryn's, who stay up to date on this information, will produce updates. But there's also industry sources, and Department of Labor itself will produce updates and keep the information readily available. The law firm blogs tend to do a good job of synthesizing the information and giving the best sound bites and not getting too involved into the wonky statutory language.
Got it. Got it. That's great. I'm not seeing any new questions as they show up here on our panel.
And anything that I was unable to, I'm sorry to cut you off, Brian, but anything I was unable to answer today, I'm more than happy to follow up with the individual if you were to get the information to me.
Excellent. 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 Kara, do you have anything else for us this afternoon?
No, just thank you guys so much for your time on behalf of the Foundation Software webinar team.
Absolutely. Always appreciate your help from the fishbowl back there. And for those of you remaining, definitely appreciate you joining us today and sticking around for the duration. Appreciate all the questions. And we'll look forward to seeing you on the next webinar. Andres, thanks again for joining us. It's a pleasure having you, and I'm sure we'll see you again.
Thank you, Brian, and thank you everyone for joining today.
Awesome. Have a good day, everybody.